What I'm going to talk about today is I think they're queuing it up, but I'm going to talk a little bit about the actual implementation of the law on the ground. And I'll talk about one of the cases, but just give a general overview. And I guess I'll let Troy talk about what's the future for the Tribal Law and Order Act and VAWA and the things that we can look forward to. But I got my hotel bill this morning, Jerry. Where'd he go? And it says a copy will be emailed to Tracy Toulouse. I'm like, I ordered a dozen $30 muffins, so I'm not sure if that's going to be a problem. So, yeah, so they're in my truck. But in 2007, our U.S. attorney came to our reservation, and she told us that there was no crime that occurred on our reservation in 2007. We knew that wasn't true. We had some homicides that had occurred, and so at that time we were actually looking for declinations, just so that our cases could be heard or brought forward. That was a long time ago, and at that time, around that time is when Troy's articles hit the Denver Post, and people, and all the work that had been done by folks in this room started to generate some real movement. We also went to a listening session with President Enos from Salt River, and this was with Senator Dorgan. And we started talking about the Tribal Law and Order Act and VAWA and some of the things that we needed. The Oliphant fix, of course, the problems on our reservations. And so today, if you fast forward to today, we're still talking about Oliphant. We're still talking about and hearing new survivor stories, some of the same problems that are occurring in Indian country, in Alaska. For all our relatives, it's still happening. But for us, we've taken a lot of the different, some of the different provisions that have been brought forward with the Tribal Law and Order Act and with VAWA, things like the SALSA program, things like the Special Law Enforcement Commission trainings, all these things that have helped the tribes gain back a little bit of restored jurisdiction, of restored sentencing authority to try to address these problems locally. We certainly had some success since then, since 2010, but of course it's described as a sliver, simply a slice of jurisdiction that we now have, and 13 tribes have actually implemented. So that's where we are today. It's certainly a little better. It makes me more hopeful for the future because on our reservation we're starting to see some of the positive effects of this legislation as implemented by our tribe. This, we talk about Oliphant because we have to, but I think today we can start talking about other cases. We can start to look at other things and the future. And so this case, this was our first VAWA case, our first VAWA conviction after the law had passed and after we had implemented and after the law went into effect. We had several cases right away. We knew that this problem of non-Indian violence on our women was a problem. And so this was our first conviction. It's a 26-year-old Hispanic male of the name Duran. He was on the reservation. The facts are, something we see every day. It's a misdemeanor domestic violence, Mom was in the home, tribal housing. She was holding her baby, walking, trying to leave the home when he tried to stop her and he pushed her. It was charged as a misdemeanor assault, and he pled guilty to misdemeanor assault. For us, it was monumental. It was the first conviction of a non-Indian since prior to Oliphant. Since then, we've had more cases. We've had more violent cases. We've seen VAWA offenders reoffend on our reservation. But these are cases that we can start to talk about. And when Deborah talks about talking to senators and congressmen, you know, their concerns were about the legitimacy of tribal court systems, about the legitimacy of our judges, our process, whether or not there would be due process for non-Indians in tribal court. Not knowing that due process and fairness is not something that our tribe learned from the Constitution. It's something that for us predates the Constitution. Fairness to people that we accuse of wrong is something that we've dealt with traditionally pre-Constitution, pre-English common law. So it's nothing new for our tribe. And so these are some of the people who work in our system. They're the prosecutor who prosecuted this case. His name is Fred Lomayesva. He's Hopi. I don't remember his village, but I'm supposed to go up there with him because I'm trying to figure out what's better, Navajo mutton stew or Hopi mutton stew. So I'm still supposed to go up with him and determine that. He says Hopi. I asked a Hopi leader, what's the difference between Navajo and Hopi mutton stew? And he said, Hopi's taste better. I said, so at that point I said, I've got to see for myself. But our Judge Melvin Stoof is Lakota. Mandaloma Ispa, she's our Attorney General. She helped write our laws. She's Lumbee. Our investigator who investigates these cases, he's Tohono O'odham. Simi Vanisi is Tongan. He's one of the investigators as well. Yvette Alvarez, she's our probation officer. She's our chief probation officer. Our chief of police, Michael Valenzuela, he's Yaqui. He's got his special law enforcement commission. The attorneys on this list are, law trained. They're bar certified. So are the judges. I would put these folks up against any court in the nation, federal or state. Our clerks are that good. It's a little mini United Nations, if you will. But these are the folks that we have working with us. They help prosecute these cases. They work weekends. They work nights. They are faced with the violence daily. So our Chief Judge, James Hopkins, he's from Canada. He's Algonquin Métis. So a lot of cool people, a lot of people that are working hard, and I just wanted to kind of highlight that fact for the folks here. It's something that federal officials have come and saw our actual system, and so these are good people, good hardworking people. These are the tribes that have implemented VAWA thus far. They're from all the way from Eastern Band Cherokee to Umatilla, Washington. All these tribes prosecuting non-Indians, moving forward. Seminole Nation, Standing Rock. All of these folks, all these tribes trying to address crime on their reservation perpetrated by non-Indian offenders. So these are just some of the numbers. The numbers don't tell a lot of the stories. There's been several problems with the implementation. Shortly after we started to implement, there was a case called Castleman that came out by the U.S. Supreme Court. It actually clarified the definition, the federal definition of domestic violence, and it essentially makes it the definition, it boils down to a physical touching, so actual assault. So imagine all the cases that we arrested on that we couldn't prosecute that weren't actual assaults. Things like trespassing, things like destruction of property, harming animals, harming children. All these things that we could not prosecute was impacted by that Supreme Court case. So we had to dismiss a lot of those cases. But these numbers are interesting. We've had 2 jury trials. VAWA requires that the juries be composed of a fair cross-section of your community. That to some people means non-Indians as well. That's been a hang-up for some tribes. We simply added our government workers and our casino workers to our jury pool. And so these 2 jury trials that occurred on our reservation they were mixed juries. Both of them contained 2 non-Indians who sat on the jury with 4 tribal members on those juries. We didn't get the outcomes we wanted in the jury trials. The outcomes were acquittals. They were based on jurisdictional issues, not the actual assaults that occurred. So the law is still complicated. It's complicated when you introduce the matter to a jury and you're asking them to make a determination on things like jurisdiction and things like, anything besides the crime that actually occurred. So it's still, proving this in court is very hard. Domestic violence cases are hard, as you know already. This adds a new layer of difficulty. The other important distinction that I just want to point out here is the extraditions. We've done 2 extraditions from Pima County. These are tribal court warrants issued by a tribal judge, domesticated in the state. Those tribal court warrants were used to pick up non-Indian VAWA offenders in the state of Arizona. They were held, we had an extradition hearing, and extradited them back to the tribe because they were absconders on tribal probation in the state. So that's, for us, that's new. For us, it's important that post-conviction process works for us. So what these cases tell us is that our system works. We can arrest, we can give due process, we can hold in our jail or a BIA facility. We can have a jury trial process on the reservation with the tribal judge, presented by tribal attorneys, and given all the due process in the world. And post-conviction wise, the system works as well. So for us, there's no longer any argument that Oliphant shouldn't be overturned. There's no longer any argument that these systems can't handle these cases and give due process to non-Indian offenders. So there's no longer any reason why Congress can't give full jurisdiction to tribes and tribal courts. Certainly there's more work to be done, but we've already proven there hasn't been any appeals, there hasn't been any habeas cases arise from these matters. That's important. We're ready to defend them in federal court. We're ready to defend our actions in federal court. But this tells us that our system works. We're scaling it out. We're talking to other tribes. Other tribes are implementing as we go. And so as that increases, this is going to help all the way around. Because when you're taking someone's liberty interest away, cases like Dollar General, which is civil monetary, challenge in federal court, when you're dealing with people's liberty interest, the monetary interest is a lot less. And so if we handle this criminal jurisdiction, there's no reason why tribes shouldn't have criminal and civil jurisdiction over non-Indians. So that's why this is important. And that's why our jury process is important as well. I went to law school because I couldn't do math, but here, I just took the number of tribes that aren't exercising VAWA jurisdiction, and I averaged the number of cases we've had thus far, and I multiplied them, and just to give a figure of what is possibly going on out there during this pilot period program. And so there's probably close to 4,000 victims in non-Indian cases if you just use the average number of cases that we've had thus far. And if you multiply 2 for children that were involved in these cases, you have close to 8,000 victims just in the past 2 years in non-Indian cases that is probably occurring in Indian country, in Alaska, in PL 280 states that there is still no injustice for. And so, although we have this jurisdiction and we're exercising it on Pascua, Yaqui, at Tulalip, at Umatilla, there's still women right now that are suffering from injustice. They're being assaulted. It's happening today. It's going to happen tonight. And that's what we have to work for. That's the future we're working for, is to address those problems that are occurring right now. This is the first jury trial. That's Judge Stoof on the bench. Not the outcome we wanted, but certainly the process works, folks. This is just an offender. He's a felon living on the reservation. The last case that we had with this person was him dragging the tribal female across the road by her hair. So he's going to probably be prosecuted as a habitual offender. And the good thing with our program is eventually we'll have the TAP program fully implemented. So his tribal court convictions will be shared with the state, with the feds, and so that can be used to enhance sentencing, to keep him away from guns. All that information will be available across the nation. And so tribes will have access to that. States, cities, counties will have access to that information. So there's a lot of things to be hopeful for at this point as we continue to develop these systems. Another offender, he stabbed a tribal member in the cheek with a screwdriver. He's facing federal prosecution for that offense. Just a little bit about the offenders. We're wondering why there hasn't been any habeas matters. They're not the most sympathetic people. Most of them have state criminal histories, violence, drugs, weapons related criminal history. So we have felons. We had a person from Oklahoma wanted on an armed robbery warrant. He was living in tribal housing. He assaulted a tribal male in a same-sex couple case. He claimed to be Cherokee. He was African American. We checked with the Cherokee tribes and found out that he wasn't a tribal member, and we prosecuted him under VAWA. He was extradited back to Oklahoma to face justice in that armed robbery warrant. So that's just a little bit about what's going on right now on the ground. We're continuing to develop. This is part of the solution in the future. Full Oliphant fix, of course. We're already giving people all the due process required under the U.S. Constitution. There's no reason why we can't handle other crimes. We have the systems, and we just need additional resources. And I'll let Troy talk a little bit about the Tribal Law and Order Act and the VAWA. These are proposed legislation that were sitting in the Senate. I think they died this week. However, they were meant to address some of the problems that we were asking them to consider this last legislative session. They'll probably be back on the table the incoming year. Thank you.